Good evening and welcome everybody. We are in a session today, and the future of India in South Asia, a discussion session. Well, a much discussed topic. This is a much discussed topic, but yet we have many loose ends in it, and that needs addressing. And so this explains the relevancy of this topic, and of course this session. Well, it is the sheer popularity of our honorable speakers today that we have reached this maximum limits of attendees in very less time now today, and it will be our apologies to those who can't log in for maximum crossing the maximum limit. However, it is the new normal now, and in this new normal, the webinar has become an invaluable tool by which we can gain valuable insights from the very best legal minds across South Asia. Having said that, I'm sure you would agree that we are privileged to have an absolute stellar panel of speakers today who have been kind enough to spare the invaluable time and their wealth of immense knowledge and experience. We're immensely grateful to the honorable speakers to be with us today. Our honorable speakers do not need much introduction to anyone practicing law or connected with legal arena. So without much ado, let me introduce our first speaker of the day. Honorable Mr. Justice Peter Mohan Maitri Paris. He has been the former the Chief Justice of Supreme Court of Sri Lanka. Speaking about him more, he has also held the office of the Attorney General of Sri Lanka in 2008. He has also been Senior Legal Advisor to the Cabinet Minister in 2011. His Lordship has also been appointed as President's Counsel in 2004. Considering his Lordship's excellence and illustrious background, his Lordship has been on several Sri Lankan delegates to international forums such as United Nations for Human Rights Council in Geneva, United Nations General Assembly, United Nations environmental programs, and so on. Talking about this topic, considering this topic today, his Lordship has been actively engaged in matters of arbitration in Sri Lanka, inclusive international commercial arbitration at Maxwell Chambers, Singapore. And I mean, where your lordship have dealt with hedging agreements vis-a-vis the volatile petroleum prices. So, without much ado, let me request our honorable speaker, Justice Peter Mohan Maitri Paris, to kindly address us on this topic. Over to you.
Thank you. I'm delighted to be with the four of you this afternoon. I'm here in my chambers in Colombo, Sri Lanka. First of all, may I seek the leave of Justice Lord, Additional Solicitor General Banerjee, and Saria, the Senior Advocate, and the organizers of the webinar. I was fascinated, I must say, with one line that appeared just a few seconds ago in your pre-runner to this discussion. And that's the little advertisement that you read. And what really attracted my attention most was that little expression, quickly settle disputes. Quickly settle disputes. Run it over again and you'll see that as large as life. My dear friends, I must confess, in my 45 years as a legal practitioner, and perhaps with my brush with almost every facet of the law, that I have yet to see a quick settlement of disputes, even by the resort to mechanisms such as arbitration or ADR. So it is only opportune, perhaps, I say that really with the tongue in my cheek, and it is only opportune that we discuss this whole topic of the comparative future of ADR practices in Southeast Asia. Now, before I do that, pardon me if I was just to refer to a few rudimentary. There are many ways of settling this. The simplest is by negotiations between the parties or their advisors. The parties themselves are in the best position to know the strengths and weaknesses of their respective cases. If they need advice on points of difficulty or controversy, they can always seek it from their lawyers, from their accountants, engineers, or other experts as required, but negotiation is unlikely to succeed unless those involved are capable of a certain degree of detachment and objectivity, qualities which are sometimes, or perhaps most times, hard to find. My dear friends, if direct negotiations between the parties or their advisors fail, the intervention of a disinterested third party, as you know, is always helpful. Indeed, as dispute resolution in international commerce becomes more sophisticated, it is becoming increasingly common for parties to an international contract to stipulate that before embarking upon an arbitration, the parties will endeavor to settle any dispute by negotiation or some other form of alternative dispute resolution, or ADR as it has come to be known. Leaving aside the possible problems of enforcement, the once a simple agreement to negotiate has become more formalized, as you know, with provision for the negotiations to be conducted under the guidance of a mediator or for some other form of ADR. We know that the growing cost of litigation, a cost not only of lawyers' fees and expenses, but also of management and executive time, made worse by perhaps unfortunately delaying tactics, overcrowded court lists, and prolonged trials of civil cases, gave rise to a search for quicker and cheaper methods of dispute resolution. Now, these tend to be grouped together under the general heading of ADR. Some of these methods, as will be seen, come close to arbitration in its conventional sense. Others, and particularly mediation and conciliation, are seen as first steps in the settlement of a dispute to be followed, if unsuccessful, by arbitration or litigation. My dear friends, it is largely believed that almost all communities in the world use some form of dispute resolution method, and that's well known perhaps in the Southeast Asian region. However, the insufficiency of data is a drawback in stakeholders deciding as to what the most favorable method of dispute resolution. Now, mediation, as we know, is one of the tools of alternate dispute resolution, having its roots, of course, in different societal norms and structures. It is a way of resolving a dispute between two or more parties in which a third party endeavors to persuade the parties to arrive at a mutually acceptable resolution to the dispute. Ideally, the methods in all our countries regarding mediation remain fundamentally the same. But the only difference perhaps lies in their origins. For example, in India, the panchayat system grew up to be more sophisticated and went on to become one of the most important forms of the out-of-court settlement mechanism in a country which we all must agree is plagued, similarly with Sri Lanka, plagued with a huge, a substantial perhaps backlog of cases. Also adding to this, there has been no track record of the indigenous methods due to the long rule of the British. Now, mediation, as we know, is one of the non-binding forms of conflict management, which is done at the free will of the parties involved in the dispute. Certain studies define mediation in perhaps a narrow sense, while attempting to capture the essence of mediation and to distinguish it from other forms of ADR. Some academics define mediation as a process of conflict management, where disputants seek the assistance of or accept an offer of help from an individual or a group, the state, or the organization to settle their conflict or resolve their differences without resorting to physical force or invoking the authority of the law. Now, most academics seem to be on the same page and agree upon the points that the process involves seeking the assistance of another, and particularly a third party, who does not have the authority to impose the outcome. And of course, this is essentially consensual. So it may be noted that there is also court-based litigation in our region, started in subordinate courts after the institution of litigation, and such cases are referred to by our courts for mediation. Now, these cases are coordinated by the Primary Dispute Resolution Center, and that's the court, in order to arrive at a viable resolution of the dispute. It must be observed, now perhaps it will be observed, and you probably know, that for example, the Singapore Mediation Center in our region offers a private mediation and has also taken steps to institutionalize and to develop the mediation services primarily at a local level. Our neighbors, Nepal, has been in practices of dispute resolution since a very long time, with aspects of mediation, but since 2001, we know, the Supreme Court of Nepal has actively promoted both community and court-referred mediation. Similarly, in Sri Lanka, mediation is based on the Mediation Boards Act, number 72 of 1988. The main aim behind this act was to improve, especially access to justice, to the economically disadvantaged groups and to prevent a backlog of cases in our courts. You'll be pleased to hear that the system is well administered and enjoys a very high reputation. A total of 400,059,364 disputes were taken up for mediation, and of them 295,302, just over 50%, were settled amicably. The settlement rate was put at 64.2%, and believe me, many Western countries have sought to follow our Asian example of alternate dispute resolution. So it is an accepted fact, my dear friends, that litigation has become an expensive and inefficient mechanism, and the mechanism for the resolution of disputes under the reason of the long procedures and the very high legal fees and the inevitable breakdown, of course, resulting perhaps in the inevitable breakdown of business relations with the disputing party when litigation is commenced. You will remember that the mediation process has been prevalent in India, particularly since the 17th century, long before the Britishers arrived on your soil. India had an ADR system known as the council system, which consisted of respected village elders whose decision was accepted by the community. Now, these old methods of mediation continue to date even within the pre-British Republic of India. And we remember that in the pre-British Republic of India, mediation between businessmen were a regular feature. So impartial and respectable businessmen at that time, known as, you will remember, the Mahajans, were asked by business association members to resolve disputes through by a spontaneous method that mixes mediation and arbitration. India followed the British adversarial system like Sri Lanka, and in India and in Sri Lanka, and accepted, as a result, accepted arbitration as the legalized alternative dispute resolution mechanism. So mediation, as we know, is a non-binding voluntary agreement to meet the needs of the parties, and that mechanism has gained its momentum in the last few years. Let me go towards a little farther east, and let's look at China. There are 4 types of mediation in China. The civil mediation happens by mediation conducted by mediation committees outside the court. Judicial mediation takes place in a court of law concerning civil and minor criminal disputes. Administrative mediation happens outside the court and is conducted by the government in matters such as labor disputes. Arbitration mediation is done by arbitral bodies in arbitration cases as judicial mediation is concerned. And interestingly, Article 35 of the Law of Civil Procedure of the People's Republic of China states that when handling civil cases, courts of law should, based on the consent of the litigants, mediate the case on the merits. Quite contrary to the misplaced misgivings we have about the Chinese legal system. Article 86 provides that the courts may be presided over by a sole judge or by a collegiate of judges, and mediation should take place on the spot, in situ, as much as possible. Article 8 stipulates that the agreement should be drawn up with the consent of the agreement, should not contravene the law. Contrary to law, or perhaps to contrary to public morals, contra bonos mores. Article 89 states that once a settlement is reached, the court should prepare a mediation document. In Sri Lanka, a serious effort was taken to reintroduce the concept of amicable settlement. Of course, it didn't quite find favor with the practitioners. Are you surprised about it? And I'm fairly sure it's a common thing right across the board in Southeast Asia. So all mediators in Sri Lanka under the Act are required to attend a training course conducted by the Ministry of Justice before they can be approved or certified as mediators. As a result, the Mediation Boards Act, the matter came to mediation in a number of ways. There were voluntary referrals, there were mandatory referrals in civil matters, there were mandatory referrals in criminal matters which were under a particular monetary threshold, and there were court referrals. And I can tell you, I have had the opportunity, the experience of having referred a complicated matter to very senior mediators with little success. I was most disappointed. So the mediation board in Sri Lanka does play a vital role, but I would really, quite frankly, like to see better results. Better results for the reason, because I'm convinced that that is one sure way of not complicating a matter and resolving a matter at the very threshold levels. Now, my dear friends, it may be of interest to note or make a brief reference to the Pound Conference, named in honor of the former Harvard Law School Dean Roscoe Pound, and which was sponsored by the American Bar Association, the Judicial Conference of the US, and the State Conference of Chief Justices. Now, when one talks of the Pound Conference, I must say, make a reference to Frank Saunders, considered the father or the grandfather of ADR, who in the course of this conference said that he went through a paper called A Variety of Disputes, Dispute Processing, and that they were best suited for, and at the end came out with the notion, he said best suited for mediation, and he came out with this notion of a multi-door court. A multi-door court, a lovely expression. Saunders says that in the paper he went through different disputes, processes, and explored what they were best suited for. And at the end came out with the notion of the multi-door courthouse. What did it simply mean? A courthouse where disputes would be screened at entry and referred to different processes or doors for their resolution. In other words, what he's suggesting is that not every cause should traverse the entire length of the tedious process that we prescribe in our civil procedure codes or in our courts. Why cannot we refer a simple dispute to a panchayat, to a lok adalat, to a mediation board? Why do we complicate simple things beyond imagination, so to speak? I must say we lawyers are responsible for it. I myself perhaps. And I must say mea culpa, mea maxima culpa. Through my fault, through my most grievous fault. I'm willing to say that from the mountaintops, so to speak. So I will leave you to investigate this very interesting area at leisure due to the constraints of time. However, Frank Sanders had a vision of how to rethink the way that people settle disputes and how to, in a lovely, again, another catchphrase, he said, fit the forum to the fuss. Fit the forum to the fuss. In other words, he said, what are you really fussing about? A simple matter that can be resolved under a banyan tree. Why take it up and start visiting it complicated principles of English law or perhaps Roman Dutch law? Fit the forum to the fuss. Send that small thing to a small guy who probably understands it much better, and not to us lawyers who are very good at complicating simple things. So, my dear friends, Frank's thinking has had an impact not only in this country. With increase in mediation and arbitration and the rise of neighborhood justice centers like panchayats, but across the whole world. Now, permit me in the next few minutes to look at the good side and the bad side of ADR. Can we, I ask you the question, can we approach the future by maximizing or perhaps pushing it to the limits of the good side and sorting out the not so good side? Can we do that? Can we use this categorization to systematically anticipate the future in order to make it truly good and help us defeat what has been described by the academics in another lovely quote as the deadening drag of status quoism? Locus standi, the deadening drag of status quoism. Look at that little quote. My dear friends, you will agree that there is much good in ADR. There's no question about it. So let's focus on them for a few minutes. You will agree with me, number one, that training and education tools and techniques are well established in ADR. Secondly, that some business schools are now teaching negotiation-based ADR as electives. We know that's happening even in our universities, in our national law universities. We know that different styles and techniques have emerged, making the field highly, perhaps versatile. We know that collaborative law is on the increase. We know that judiciaries have increasingly embraced ADR in its various forms. And I can tell you a good example are the courts of California. I had two judges from the Ninth Circuit of the United States Court of Appeal with me here in Colombo. And believe me, the amount of work they did sitting down in Colombo pertaining to the work in California. And he told me, and mind you, I got them down here to teach our judges mediation. They were shocked at what we were doing. They sat in my Supreme Court one day, just for half an hour, and said, Chief Justice, I like to sit in your court just to watch what you're doing. So I allowed him the privilege of sitting there. And I adjourned for tea that morning just to get them a cup of tea, rather early. And over tea, he cracked a joke at me and said, Chief Justice, don't misunderstand what I'm going to say, but you are doing the job of a clerk in the last 1 hour. Isn't that true? Touch your hearts. Look at our courts. What do we do for most of the day? Pushing files here and there, giving dates, adjournments, arguing on something absolutely useless, giving directions, doing everything other than the core activity. So what have the Californians done? The Ninth Circuit of the United States Court of Appeal, they have reduced it to mediation. You have to mediate. Then we also know that the success and satisfaction rates for mediation, negotiation based on ADR are high. We know that. Give me an example of one of your clients who would want their problems resolved in a few days rather than a few years, perhaps a few generations. Arbitration, we all know that arbitration institutions are embracing ADR processes far beyond arbitration. Why? We also know that governments and international organizations are increasingly supporting ADR. I was once doing negotiations with the World Bank in Washington with our Secretary to the State for Finance. And the World Bank said, Chief Justice, I'm only making one plea from you. We'll give you any amount of money for judicial reform. But just do one thing. I said, what is it that you want? And he said, we want a return for our investment. I said, that's rather strange because we don't actually give returns on investment. He said, no, it's not that kind of return that we are talking of. The return we want for our investment is a speedy disposal of cases, or your little cliche in your advertisement, quickly settle disputes. And finally, we know that court schemes there are court schemes that robustly encourage ADR are on the increase. Now look at those plus points. Can we ever turn a blind eye to that? No. My dear friends, the picture won't be complete if I don't take you through the downside of ADR. The downside to ADR, of what I have seen, is number one, anyone can call themselves a mediator, collaborative lawyer. There are some fancy terms, very amorphous in their own right. But they're really not competent mediators or collaborative lawyers. They do anything but that. Look at the time the arbitration takes in our jurisdictions. It has become, perhaps with all respect to my colleagues in the Supreme Court, a haven for us retired judges. I'm sorry to say it, but these are hard facts. Secondly, few professional bodies exist with leadership standing to self-regulate the field. Nobody wants to regulate it. Why? Because you want to be popular. Because you won't be retained to do mediation or arbitration. You have to be a popular arbitrator. Oh, he's a good guy. He allows a postponement anytime I want. He drags it on. Let's have arbitration over cake and coffee, so to speak. Thirdly, most training does not result in a credible qualification. Training standards vary. Nobody knows where it is. In other words, there is no set training standard. Fourthly, the field of ADR lacks objective transparency on standards. We don't know, we don't get a feedback, and the ethical standards perhaps are unprescribed. There are few experienced generation schemes. There are no experience generation schemes. How do you gain experience for new mediators? How do you give them experience? Where do you teach them? Where do we have a trial run on it? No. So in other words, we train at the expense of the litigant. There is inadequate diversity in terms of gender and professional background. Count the number of women who do mediation and arbitration. Is it because they don't know it? Just look at that. And there are a number of matters that probably involve the different genders. Think about it. Practice fields are narrow. Few human rights, very human. How many matters of human rights comes up for mediation? So practice fields are narrow. How many investment matters? How many state matters, and how many matters come up? The field of practice, look at that in human rights, in investment, state matters, tax mediators. See how many people, how few are there? ADR limits the perception of the field to alternative and to a dispute focus. So it's looked at as an alternative and we focus on a dispute. It's not as easy as that, you will appreciate. Few mediators, I must say, acquire intercultural skills to supplement their mediation skills. Would you know the cultural practices? Very few of them are sensitive to it. And there is a very slow uptake of ADR in some key sectors, such as, for example, intellectual property. How many dispute resolution alternatives have we resorted to in intellectual property matters? Tell me. None, perhaps few. Now, there is also another grouping, and that is the most discouraging side to it. The most discouraging side to ADR in our whole region, and for the perhaps that we should really address for future posterity, is that the field lacks effective leadership implementing a common basic strategy. Do we have a common, has anyone given us any leadership with regard to the implementation of a common basic strategy? Is there a widely shared vision or action plan for the future? Have we? Everyone thinks that they are great mediators, they are great conciliators, they are great arbitrators. Do they really have a widely shared vision or action plan for the future? What do we leave for our future generations of lawyers? You will also appreciate that funding support to grow the field is grossly inadequate. How much of funding is put away to support the field of ADR? You will also see that the field is decided into hostile power blocks, fragmented, and key players fail to collaborate. You will see that one group of mediators perhaps snuff out are in competition. They are hostile power blocks, fragmented, I would say balkanized, fragmented, broken up like the Balkans. And key players fail to kind of harmonize their work for the greater good of the nation, of our nations in the region. Wouldn't you agree that there's a failure to self-regulate that will lead to forced, inappropriate government regulation? That happened in India just a few months ago. We were taking our time over arbitration, and the government said, that's enough is enough. You shall finish your arbitrations under 1 year. And that's happening all over. The government steps in and says, that's enough. The fun and games must stop. The limited, perhaps, the limited practice in the field relies on unconvincing or perhaps no data. We have absolutely no databases as to how mediation has progressed. We have nothing to have a referral to how it works. You will agree that the inertia and apathy too often feeds that what I call the deadening drag of status quoism. Arbitration, mediation, conciliation is really considered to be for the elite, for the socially acceptable, to the socially capable, the capacity to retain very expensive counsel. So it is my considered view, and I agree with the academics, that we need to begin with a shared vision. There is a very well-known Japanese proverb, my dear friends, that vision without action is a daydream, and that action without vision is a nightmare. Think about it. Truism. Clearly, we need both the right vision and the right action. What then, I ask you, might be a realistic vision for this field in Southeast Asia in the decade ahead of us? I ask you that question. What should be our vision? So mediation and other consensual problem-solving processes will be the primary way, in my respectful submission, to avoid, mitigate, and resolve conflicts throughout the world. The simple vision, this simple vision, there is a vision at the moment, but this simple vision is currently lacking expression in the ADR field on a shared basis. Some people have vision, others have less vision, some have no vision at all. But that surely cannot be the case. It may be in people's minds, but they have not committed to it because the right action plan has not been identified. The result is that it remains a daydream. To become achievable, the right action must also be identified for the region and adopted on a widely shared basis, and it needs to be action that leads directly to the accomplishment of that vision. My dear friends, may I round this off? Before suggesting the right action, I ask the question, what is it that can make this vision a reality? You will agree that one of the drawbacks of ADR, as one academic describes it, is how fragmented the discipline is. It's completely fractured. This fragmentation needs to be eradicated, removed. We need a collaborative platform from which the legal profession can address its future. Without that collaborative platform, there is nothing to bring us together. And we will continue to drift virtually in space. And I believe there are a number of things to achieving that right platform. We must have in our nations in Southeast Asia, if we want ADR to develop and flourish, a national professional body in every one of our major countries. Those professional bodies must compete. They should not be competing as service providers. They cannot compete as service providers. Why run to Singapore? What's wrong with our own provisions? And it must dovetail into a global network of national professional institutions. My dear friends, it has been said that the main obstacle is the absence of a widely held perception of true independent professionalization of this field. We don't have dedicated true professionals that we are churning out of our universities, in our law schools, and so on and so forth. They are not picking mediation and arbitration as a career. Everybody wants to run to our courts, or perhaps to one of these centers that are running call centers. Until that happens, you will agree, with a professional body present and visible in our countries, that common platform, right, underpinned by academic training excellence, that lends itself out to achieve that vision, and no basis for other shared action that needs to be taken to change the world of ADR for the better. So that is what we need to urgently do. Let's look at for a few seconds, a few minutes on the action plan for the future. My dear friends, it must be something it must be something more than a dreamy idea. We can't be a set of dreamers. Think about it. Academics say, this is not something that I'm saying, I've been reading on this quite extensively. Academics say that professional bodies will inculcate consistent high levels of competency standards for mediators and party representatives linked to a consistent, transparent, credible credentializing system that implements those standards. In other words, it's not every small fellow or every incompetent lawyer who can be a mediator. Mandatory continuing professional development expectations will be introduced. They also say that practitioners will voluntarily become credentialed to distinguish themselves publicly as part of the profession, declaring adherence to the ethical code, participating in continuing professional development, and publicly declaring their credentials. In other words, look at it, my dear friends, how many of us participate in continuous legal education, even at a senior level. Remember that as time goes on, we as human beings, our memories must fade with time. And we need to keep ourselves abreast of the laws. They also say that governments should lead, but derived also from other stakeholders, there will be serious funding for all other professional bodies. In other words, even the government should be called upon and said, look, if you want to actually address this massive backlog, for heaven's sake, invest in ADR. They also say that a research ethos and the generation of key statistics by educators and others will now be funded, as well as experience sharing. There must be experience sharing within the profession. Do we do that? Can we think of the application of funds to raise awareness amongst users in the region so that the value mediation adds will be far better understood and therefore much more widely accepted? Is it possible that professional bodies will encourage greater diversity in the global profession, correcting the current domination by perhaps, I'm sorry to say, but white Anglo-Saxon male lawyers, and encouraging diversity of specializations into human rights, corporate social responsibility, intellectual property, and tax law? Professional bodies not being service providers or competing in the marketplace will act as conveners, approaching parties to propose a problem-solving process suitable for and tailored to our own circumstances. My dear friends, the list, I can set out a litany of things that we in the region must resort to improve our area of ADR. I believe that with this shared vision and an action plan, it is within our collective grasp to take a giant step over the next decade from a field or discipline into a fully fledged global profession and be recognized as such by users and other stakeholders everywhere. I might encourage you perhaps to draw encouragement from what I would describe as a groundbreaking development. It's on record. In August of 2012, you will remember the Mediation Committee of the American Bar Association's section of dispute resolution expressed its support for local innovations in mediator credentialing, provided they meet 6 guidelines of what an effective credentialing program should include. I would leave you to do your own research and to discover what that criteria is. I can assure you that it is well considered and exhaustive. My dear friends, if I was to just go back for a few minutes to Nepal, Nepal has been in practice of dispute resolution, as I said, since a very long time, with aspects of mediation since 2001. And I said the Supreme Court has actively promoted both community and court-referred mediation. So have the African countries have done, and perhaps so has Sri Lanka. And the main aim behind this was to improve especially access to justice to the economically disadvantaged groups and to prevent a backlog of cases in our courts. My dear friends, we have spoken much about mediation, which lies at the heart of ADR. There are, of course, we know, however, other forms of ADR, such as conciliation, such as mini trials, such as neutral listener agreements, such as baseball or last offer arbitrations, interesting mechanisms, such as Medalova, which is a combination, a hybrid between mediation and a last offer arbitration. And then we have court-annexed arbitration. Then we also have summary jury trials in some parts of the world. You can read about it. We don't have time to discuss it too much today. And of course, there are other techniques that are particularly in the North American continents. So there you are. Then, of course, finally, I must wind up by making one little reference to arbitration. We all know what arbitration is all about. I don't need to tarry over it. But needless to say, if I just was to summarize the characteristics of arbitration, it's a voluntary process. It's private. It was meant to be quicker. Is it quicker? Am I getting my language wrong? It was meant to be quicker. It has to be cooperative. Arbitration is voluntary, but is not cooperative. It's voluntary, it's cooperative because it is voluntary. Voluntariness requires participation of the parties. Arbitration uses independent third parties to assist resolving disputes. It's not binding. And mind you, what is interesting is that ADR proceedings do not interrupt the running of time limits, which is another interesting feature. 47% of the arbitration cases are settled shortly after the plea has been filed. The advantages of arbitration: cost, speed, control over the process of arbitration. ADR is not, of course, you know that ADR is not adversarial. And of course, there is confidentiality. There we are. Of course, there are disadvantages. There are uncertain standards in arbitration. Fear of early, perhaps pre-litigation, pre-arbitration disclosures of arguments. Cost saving, not necessarily achieved. It requires a reasonable good relationship between the parties. Now, just to pose one little question finally. Is arbitration ADR? It might be thought that the term alternative dispute resolution would be used to describe any methods of resolving disputes other than those adopted by the courts of law as part of the system of justice established and administered by the state. On this view, arbitration would itself be classified as a method of alternative dispute resolution. Why? Because it is a very real alternative to the courts of law. However, the term alternate dispute resolution is not always used in this wide, or it might be said, precise sense. One academic said that alternate dispute resolution and she described it and said that it presents an arbitration, he said, presents an alternative to the judicial process in offering privacy to the parties as well as procedural flexibility. However, it is nonetheless fundamentally the same in that the role of the arbitrator is judgmental. The function of the judge and the arbitrator is not to decide how the problem resulting in the dispute can most readily be resolved, so much as to apportion responsibility for that problem. It is tempting to suggest that distinction between ADR on the one hand and litigation and arbitration on the other is that while litigation and arbitration are compulsory, ADR is non-compulsory method of a resolution of disputes. So ADR, like litigation and arbitration, will often, you will appreciate, involve an independent third party, but its function is fundamentally different from that of a judge or decision of the parties. But on the contrary, his role is to assist the parties to resolve the dispute, and he may give opinions on issues in dispute, but his primary function, as we all know, is to assist in achieving a negotiated solution. I always never fail to, when we talk of ADR, fail to refer to this lovely little story of two parties who were disputing the title to the same consignment of oranges. They were fighting over the same consignment of oranges. A mediator soon heard them both, and they soon found that the matter could be easily resolved. Why? Because he found that one of the manufacturers wanted the orange rind to make marmalade, and the other claimant wanted the orange itself, the pulp, to make orange juice. So the same consignment of orange juice were kind of used by both parties by mediation. One party skinned it, took the rind and made its marmalade, while the other party took its pulp and made its orange juice. The example drives home the effectiveness of being able to talk to parties, play the role of diplomacy between disputant parties. My dear friends, I think I have said enough, and I have left enough sufficient food for thought as to what we should be doing for the future of alternate dispute resolution in Southeast Asia, perhaps in the future. I hope and pray that we will all, irrespective of where we are in the region, that we will soon apply our minds to making life easier for ourselves and perhaps for our brothers and sisters who are less fortunate than we are. The law is the law of the people. The law doesn't belong to lawyers. It doesn't belong to judges. It doesn't belong to legal academics. The life of the law is the people. It is embedded and rooted and is autochthonous in the sovereignty of our people. So let's try and make life a little easier. Remember that all these mechanisms that we resort to, finally, laws are meant to keep our people happy. At the end of the day, we must be, I'm not saying not joy, don't mix it up with joy. I'm saying to be able to live in dignity and in satisfaction. And that is fundamentally what our laws are meant to do. And I'm a strong believer that ADR can play a vital role, right? And we probably need to now start thinking of decolonizing our laws and start introducing our own simple methods of resolving our disputes that our elders did, right, in the generations that have gone. And we look to better times and a better future for the region. Thank you very much for inviting me this evening to present to you these few ideas. And I hope that these few ideas that I threw up this evening would be of use in putting in place a better legal system in the future in the field of alternate dispute resolution. Thank you. Thank you.
And our very first speaker, and His Lordship has very eloquently touched all the quadrants of this topic, and lastly touched the spirit of the topic. To sum up what His Lordship has said, may I just say, His Lordship very eloquently explained about the concept of idea, its origin, and also the origin trans-border. His Lordship also spoke about the institutional mediation centers and also described various reasons for the lackluster condition of the traditional court and justice delivery system. His Lordship has also mentioned about legislation available in Sri Lanka and also the promising results that has yielded with facts and figures. His Lordship has very well highlighted and explained with illustrations about area, mentioning about Frank Saunders and multi-door courts. His Lordship has also mentioned about the illuminated and dark side of area, and also has raised a very pertinent question, so that why area is not available in human rights trial or some in the right fields. Maybe we can have this as a discussion topic after all the honorable speakers have done with their deliberations. Thereafter, his lordship has also mentioned about various forms of area and has suggested, while concluding, that we should go for decolonizing and have our own ways of area. Well, sufficient food for our thoughts. I feel that the craving and the appetite for knowing more on this topic has all the more increased. And so I would be inviting our next honorable speaker from the stellar panel of speakers, Honorable Justice, Mr. Justice Arindam Lode. If I am to say about him shortly, however, he doesn't need much introduction. His Lordship is a sitting judge of the Honorable High Court of Tripura. His Lordship has been elevated in 2018. His Lordship specializes in the field of constitution, civil, criminal, taxation laws, property, intellectual property matters, etc. His Lordship has has held the post of CGC, Counsel for the Railway, in the Agartala bench of Guwahati High Court. His Lordship was also appointed as a standing counsel for Indian Railway, Indian Oil Corporation, Regional Provident Fund Commission, etc. His Lordship was also appointed as Assistant SG Government of India in the year 2009 for Agartala bench of Guwahati High Court, and also a senior panel counsel for the Government of India. His Lordship during his practice life has an illustrious contribution in the field of area. His Lordship has been a trained mediator. His Lordship has appeared in a number of leading arbitration matters representing long range of clients, including MNCs and also state and central government of India. Therefore, without much ado, to serve the palate of the hour, may I request Honorable Mr. Justice Arindam Lode to make his deliberation. Over to you, my lord.
Thank you, Mr. Bhattacharya. After such brilliant deliberations by Justice Paris, there is nothing to say. We almost covered all the topics about the ADR mechanism in the subcontinent. However, let me start with the words of Abraham Lincoln, who said that discourage litigation, persuade your neighbors to compromise what you can, point out to them how the nominal winner is often a loser in fee, expenses, and waste of time. In our society, we cannot live without contradictions and conflicts. It's a regular phenomenon. And perhaps these contradictions and conflicts tell us to maintain peace. Now, the peace is a sine qua non for development, and one of the most important facts which help maintain peace in our society, in the society where people straight in the justice delivery system prevail. Now, these conflicts and contradictions lead the litigant, lead the people to approach the court. A very complicated legal process we have to go through. And the law is codified. Now the maximum laws are codified, and we cannot go beyond the codified laws. We are bound by those codes. So, and the result is the shortage of judges in all the courts, in the perspective of India, we are running shortage of judges. Perhaps the same situation in other countries also. Here, so we are clogged with number of cases, huge number of cases. It results unnecessary expenses, waste of time, and we get the result after even after 3 decades. Grandfather starts the case, and his granddaughter or grandson receives the result. This is the system we are going through. This is the, in my opinion, most unfortunate phase, most unfortunate system. Now, our thinkers, the legislators, thought it fit to resolve something, to do something so that people, we can deliver justice quickly to the people. For this, in the year 2002, our country, India, has amended Section 89 and Order 10, Rule 1A, B, and C, and adopted those mechanisms and binds the court that after framing issues of disputes regarding the disputes, parties should be asked to resolve the disputes by some mechanisms. These mechanisms are maybe through appointment of arbitrator, by conciliation or reconciliation, by negotiation, or by judicial settlement through Lok Adalat. For this, we also have introduced the law, Legal Services Authorities Act. Through this mechanism, we have received huge response, and in the meantime, lakhs of cases throughout our country have already been disposed of. That in our country, there is a system of introducing national Lok Adalat. We conduct Lok Adalat at least 8 to 10 days in each year, and state-wise also, we conduct Lok Adalat at the initiative of Legal Services Authority. These are the things. So we can proceed. The mindset. The basic is the mindset. We have to change the mindset, and advocates have a great role to play. They are the persons who may motivate the clients to think in an alternative way to resolve the dispute. It is very shocking when I see, after my elevation, when we hear the criminal cases, that a person has been imprisoned and he has suffered imprisonment for at least for 4 to 5 years, and after suffering imprisonment 4 to 5 years and even 6 years, 7 years, we find that his offense has not been proved beyond reasonable doubt. So we have to acquit him. This is the criminal system. So it really hurts everyone. It not only spoils the life of that person, but also the life of other persons of his family. Perhaps it destroys his family structure. Naturally, in civil disputes, 20 years, 30 years, it starts with magisterial court, then district judge court, then high court, then Supreme Court. In the meantime, the person who instituted the suit died, and he could not enjoy the result of the suit. So, ADR, so our legislature has introduced the ADR mechanism through which we can go to the conciliator, to the arbitrator in commercial litigations. I may tell my personal experience when I was an advocate, because here many litigants may hear this seminar, may this conference. In my practicing life, I conducted a case on behalf of it was a divorce suit. It was a divorce suit. I was defending the husband, and in the courtroom, the wife slapped the husband, made a huge slap towards her husband. The relationship, everyone may think of the extent of bitterness, the gravity of bitterness between them. Then in the evening, I sat with them. I tried to identify the disputes between them, actual disputes, the issues regarding the disputes. Then the wife told, I'll not stay with the parents of my husband. And the parents say, I cannot leave my parents. It's my duty and obligation towards my parents to look after them. The wife said, no, I am very much comfortable with my parents, and he used to stay with me. So both are very adamant. I then try to pacify the husband. Okay, stay someday. For a few days, you stay with the wife at her parents' house. After a few days, he came. All right, sir, I'll stay at my wife's house. After a month, both of them came and said, no. Wife said, okay, I will not stay at my father's house. I will stay in a rented house with my husband, but not at the house of parents or of his parents. Okay. The husband, I also pacified the husband, stay, agree with her. Okay, sir, agreed. Then they started to stay in the rented house. The husband was earning rupees 10,000 per month, and they had to pay a sum of rupees 3,000 at the rented house. After a few months, the wife felt it was very hard to live the livelihood, to lead a comfortable life. Both of them came and said, no, sir, okay. I am ready to stay at the parental house, but at separate mess. There should be separate kitchen. I specified the husband and also the parents of the husband. Both of them agreed, and they started their life very peacefully. Few days ago, I met with them in the market, and now they are living their life with 2 children.
Okay,
so this is the way it acts. If I, as a lawyer, I would not have taken that initiative, perhaps litigation still going on. So this should be the approach. This should be the mindset of the lawyer, as well as we always try to persuade. So another example I will give in commercial, in one tender matter, between company, Indian Oil Corporation and the other party, the contractor. They started with the High Court, referred to arbitration. Then I sat with them. I was the counsel for Indian Oil Corporation. I said to him, what is the demand? Identify your own issues. What are the disputes? What are the issues you try to raise in the arbitration? Then they were agreed to appoint conciliators. Then conciliators were appointed. Two conciliators were appointed. And through conciliation, because in arbitration, as you know, we have to, there are so many technical, then evidence, all the papers, the statement and counter statement we have to file. And through conciliators, it is solved. It was resolved. The disputes between them was resolved within a period of 6 months. We all know, even if one party in arbitration proceeding, if one party wins, then the other party may go to civil court, challenge the award. It may come to High Court, then it may go to Supreme Court. The time consuming, but within 6 months they get the result. I am saying all these things for the listener who are listening this conference, this seminar. So try to, the people, it is the duty of the people also, the citizens also, to change the mindset. There is, in family matters, it is very easy to resolve the disputes. Disputes between husband and wife, just to identify, as a mediator, it is the role of the mediator to identify the disputes, then come to an agreement, place it to the court, the order and decree. Because mediator cannot pass any order. He is to just reflect the issues of agreement. So conciliation to arbitration, it is settlement. On that settlement, the court will pass decree, the award. So these are the, in India it is not new. Actually, in ancient India, the law was like that, moral law, based on morality of people. There is no any codification, any nothing else. Our sages, our rishi used to tell, the people used to hear them and comply their directions. There is no codified law. After there are panchayats, the disputes are settled by panchayats, by the elders, even by the elders of a family. The issues used to be settled. The disputes have to be settled. Then after British rule, the codification comes of various laws, and now we are followed. Then after independence of India, for 2 days, its Panchayat Raj system was there, but it was abolished once again. Again it came back, and now the huge funds are given to the panchayats, and in many cases, many disputes are resolved by panchayats. If the disputes are not settled, I am telling you, in our state, 50% disputes are settled by panchayats. I have our personal experience. So the mindset of the people, the mindset of the citizens, the mindset of the lawyer, the mindset of the panchayat, the girl the Gau Sabha, the leader of the villages, they are also to be neutral. They have also obligation to the society. Now the problem is infrastructure, the expense. Who will bear the expense? Infrastructure is a great issue. We to actually people to know the people, we have to we have to conduct various camps. Now, from where the funds will come? Central government distributes funds. We receive funds through uh, legal service authority of Supreme Court, and the maximum funding are made by the central government. So we conduct various camps at various places. The government also should take the initiative. The persons concerned, the high courts, the magisterial courts, all should be concerned that we are to publicize the thing, that the disputes can be settled by these and by the other systems also. In our camps also, we invite the litigants and settle the dispute. Identify the issue, settle the dispute. So this is the way we can take advantage of ADR mechanism. These are the technical scenarios which we are to adopt. And I convey to the citizens of all the countries to adopt this mechanism, to change the system, not to prolong the litigations, not to involve in, not to waste time. In America, in United Kingdom, Sweden, it has become very successful. Justice Paris has told just a few minutes ago that in Nepal it's working very well. So in India also, we expect more. It will be very advantageous to the people and to and to render quick justice to the people, to the citizens of the country. Mahatma Gandhi so eloquently remarked, both were happy with the result and both rose in public estimation. I realized that true functions of a lawyer was to unite parties. The lesson was so indelibly burnt into me that a large part of my time during the 20 years of my practice as a lawyer was occupied in bringing about private compromises of hundreds of cases. I lost nothing thereby, not even money, certainly not my soul. So with these words, I want to conclude myself.
And persuade your neighbors to compromise wherever you can. As a peacemaker, lawyers have superior opportunity of being a good man. There will be business enough. Aptly reiterated by Honorable Mr. Justice Lord. To cutting the long short, Mr. Justice Lord has mentioned about, just to sum it up, mentioned about the uh, ascribed reasons for the lacklustrous condition of the traditional court system, and also mentioned about his practical experiences when as a mediator, as a counsel. He also suggested how to deal with the sluggish court system, which almost a common scenario around the entire Asian region, should I say that way. And he has addressed the elephant in the room by mentioning what various other issues and how to deal with them. Well, with this, well, Coming to our next eloquent speaker, uh, well, he does not require much of an introduction. He's a known face in the entire India. Well, he's a very seasoned senior counsel and honorable additional solicitor general of India, Mr. Vikramjit Banerjee. Mr. Banerjee also held the office of AG, Advocate General for the State of Nagaland in 2015. Mr. Banerjee, sir, he has also co-edited various literary works in the legal realm and also in other fields, like one in 2008 titled as The Truth About Tista Siddharvat, which got elated elaborate reviews. Well, I just cannot resist myself from mentioning about the tasteful temperament which Mr. Banerjee has. We as advocates always look up to him that way. While Mr. Banerjee makes submission before the Honorable Court, he is a charmer at best. So, well, let me not keep us anymore waiting. Over to you, sir. So, sir.
Thank you, Kohinoor. Kohinoor, as always, is terribly, terribly kind. He's deeply flattering and terribly kind, but I don't think he's as close to the truth. But that's a separate story altogether. Thank you, Justice Lord. Thank you, Chief Justice Perez, for the wonderful lecture. And both of the lectures were extremely illuminating. And I think Justice Perez's lecture was, in many ways, I think I would say is my locus classicus, which I've heard on the area of ultimate dispute resolution in South Asia. I think if Kohinoor could do something about it, maybe record it, I think it's a fantastic speech. And I would also thank Justice Lord for really concretizing the speech and making alternate dispute resolution, the idea of alternate dispute resolution quite applicable, and how it's actually applicable on the ground. Because we tend to get carried away with conceptions, but Justice Lord has had a lot of experience as to how it's been done. I prepared a PowerPoint presentation, which I told Kohinoor that I will present. But I think, Kohinoor, my thing is that I'll let this go. So I'll give a broad outline as to what I will. So you can, we'll do away with the PowerPoint presentation. Even though I had actually, my PowerPoint presentation, which I made the presentation on, was largely on developments of arbitration on various different countries.
If you may request,
developments
in that case, I can get the PowerPoint.
No, I don't think. I'll just summarize it. You can circulate it. That's not too, because a lot of things which have been already been covered by Justice Perez and Justice Lord, and I don't want to go back on the same path. Broadly is this, that what have been the large developments in different countries. It was sort of going to different countries in different parts of South Asia. But coming back to the main question, and I think that's extremely important. And I think if Kohinoor wants, Kohinoor can circulate the PPT to whoever is interested, if they're interested. But coming back to what we were, the topic of the discussion today. I look at alternate dispute resolution as a part of life, as a fact that it has always existed, at least in the subcontinent. For I'm leery of using the term South Asia, because Asia is a term which comes from Europe, and South of what, as people say. So, but definitely, but if we look at as a common set of people, as a common set of people who inhabited this large piece of land, and whose cultures have influenced each other for millennia, and could be broadly construed to be a part of common cultural civilization. The conception of something alternate dispute resolution has been an integral part of jurisprudence of this country, of not only this country, of this broader civilizational cultural area. Now, I'll just illustrate some of the stuff, some of the places which you may have already heard of, and then I'll continue as to the rest of the presentation. methods, or I construe alternate dispute resolution as a method of resolution of disputes which exist outside the strict state system of courts. Now, for example, throughout history, if one reads the Arthashastra, and you would know that there are courts mentioned, and the king governs through royal courts, and there are ways and things are governed, and justice is delivered through the royal courts. But there is a continuous history, and this is something which we should, and that's why possibly, our justice system, effectively a justice law, very interestingly said, and that's some statistic, which is a very interesting statistic, I'll get back to that later, as to how even today most of our disputes are still settled outside the normal court system. That is because it's culturally close to us. That is because it has always been that way. It's not something, alternate dispute resolution is not something new to us. It's something which we have always done and we've always treasured as a culture. One of the fundamental reasons why I think alternate dispute resolution still exists is, and I'll say this very controversially, is because we as a culture prefer the conceptions of justice, which broadly in terms of English law would be considered as equity. We tend to prefer equity or justice more than we do prefer law. So in a lot of my discussion, I say that, we are a country which is ruled by the conception of justice and not necessarily by the rule of law. But as we know, historically, rule of law and equity have been complementary to each other, also in common law. So maybe that may be not so precise a premise, but it's also because we prefer justice. We prefer complete justice, which may not strictly be possible in terms of the law. Historically, if you've seen the Arthashastra of Kautilya, which was the basis on which the Mauryan state was formed, and which is one of the texts which can be seen, which has been greatly influential on the civilizational, cultural, legal systems of this subcontinent through the Mauryan Empire and Ashok and the various different legal systems which resulted as a result of that. The Arthashastra very explicitly recognizes the space for alternate dispute resolution, both at the village level as well as, interestingly, on the guild, or interestingly, and on business, between business people. Now, this proposition is also recognized in some of the Dharmashastras, in Manu's Dharmashastra, in various different Dharmashastras, which were contemporary at that point of time, which also recognized very, very, very clearly this conception of having a system whereby the people resolve their own issues amongst themselves. In fact, as I would take you back and sort of illustrate how the Panchayats recognizes that. But if someone sort of contrasts, and this is a very interesting contrast between the Arthashastra and Dharmashastra, people would obviously very clearly tell you, while the Arthashastra relies on state power to implement decisions, or is largely a text on how a state is run, Dharmashastra is not. The Dharmashastra describes what people should do in certain situations. It's not an Arthashastra which designates punishments or designates procedure. Our Dharmashastra is a text which indicates what one should do. So whether one goes to the entire gamut of all the Dharmashastras which existed at that point of time, primary being one is Manav Dharmashastra, and many of them, it would be very clear that the Dharmashastra actually sort of relies on societal pressure for implementation. And because the decision making is done outside the strict confines of the state. So the society which Dharmashastra envisages is in many ways a alternate dispute resolution, a resolution which exists outside the state. Now, this sort of resolution, as Justice Perez, I'm sure, would also be aware, is mentioned very frequently in the Jataka tales. So it's not something which is unusual or historically unknown to subcontinental civilization of thinking. And most incredibly, and this, I was having this interesting conversation with Justice Perez yesterday, when I was saying that I remember reading, there is a book about the Buddhist Sangha, and when the Buddha, Sakyamuni Buddhadev, formulated his Sangha, which became the basis of Indian civilization, which deeply influenced Indian civilization for millennia. The entire sort of how are disputes to be resolved was a question, because the Sangha was a very vast organization, length and breadth, very diverse. And it used to run monasteries, and how are monasteries to be governed, how are disputes to be resolved, which happens between different monks. And there was extremely elaborate procedure which was laid out as to how these issues are to be solved. Because the Sangha also had large amounts of land. So, this very interesting conceptions of alternate dispute resolution have always been a part of the subcontinental thinking. In fact, anyone is also aware Mahatma Gandhi, when he wrote his only political text, and he said that my only political text which I've ever written was the Hind Swaraj, and where he actually said that if we have to prosper, if we have to have an Indian independent state, then it's essential, or a state which is in tune with the wishes of the people, in tune with ideas of which exist in the country. Then he wanted to get rid of the legal profession. One of the reasons why he wanted to get rid of the legal profession is the adversarial nature which was inherent within the legal system, the British legal system. And he always said that you cannot have complete justice in the country unless the justice system is in tune with what the people are used to. Now, he advocated, as we all know, and all of us in India at least are extremely knowledgeable, are aware, it's part of our thinking that, and it's quite extensively taught, that Mahatma Gandhi actually spoke about a village-based system, and his sort of dispute resolution system, which he also advocated, was largely village-based. Now, these are old civilizational ideas. Mahatma Gandhi never said that he's inventing something new. His Hind Swaraj was very, very explicit that he that he was relying on the old civilizational ideas, and he was relying on, and he said that you can only have complete justice in this country if you follow civilizational ideas. Now, we still have these things today, and it exists. And what Justice Lodh said was, I think, is absolutely and completely correct. Alternate dispute resolution exists. It is an integral part of our lives. The impact of the court system, which we see and I can say explicitly in India, I won't talk about other countries because I am not that deeply knowledgeable. But I agree with Justice Lodh completely that the impact of the justice system that we have today, the British colonial, the justice system which we inherited from the British, the rule of law-based justice system, actually does not go very deep. In today's India, all of us know that large amounts of our disputes, little outside the cities, little outside the smaller towns, is still decided through panchayats. I know very frequently that even today, if there are village land disputes, is still decided in terms of panchayats, and the panchayat will be called when disputes are sorted out, boundaries are designated, issues are sorted out, family law issues are sorted out, marriage disputes are sorted out. Effectively today, even today, panchayats are actually the place where large parts of India go to when they have a dispute. So it's extremely interesting in that we still will retain it, and we still accept it, that it works. The Indian state has tried or attempted to sort of recognize it through having Gram Panchayats and Nyaya Panchayats, and devolving some powers to Nyaya Panchayats to decide on certain smaller issues. But I would say this, even bigger issues are decided panchayats informally. The state's attempt attempt to recognize Nyaya Panchayats is only a part of the state to recognize the reality in India that a large part of our disputes get decided actually in panchayats. And I'm from Bengal, and I know in the village panchayats are still extremely important, and still decide large amount of the disputes which arise today. Very few people from villages actually prefer to approach the local courts, district courts, sometimes because of the distance, sometimes because of also the barrier of the expenses, as well as the mental barrier of having lawyers, of appearing before a judge. So people still prefer to go to the panchayats to solve most of their problems. Now, the conception of alternate dispute resolution that we have today is which we see in our arbitration, conciliation, and mediation provisions in the Arbitration Conciliation Act is something which is new. This is a product of I would say, of globalization of the 90s, when in many ways, when because of the impact of globalization and because of the fact that companies and commercial interests and companies were working across the world and across different legal jurisdictions, they wanted some sort of certainty in the solution of disputes. The first area which, of course, received a lot of their interest of these international commercial interests was arbitration, because they felt that it was unevenly, because commercial laws were unevenly implemented, and also because there was no certainty as to how a contractual dispute will be solved in case it arose. And because there were now, in many ways, international companies which were working internationally and globally, that became a major issue. So all of us know that in the 90s and through the 2000s and 2010s, at the height, when globalization was like at the height, there was a huge push for the conception of arbitration to be applicable across the board, and for arbitration, most importantly, arbitration awards to be made implementable. Now, across Southeast Asia, as we know, and all of us know, that it was difficult. There was a huge pushback from people to make arbitration awards implementable. At least in India, I know there were the courts on various occasions tried to sort of sit as appeal courts on the conceptions of arbitration awards, to judge arbitration awards, to be an appellate authority of arbitration awards. But I think also on commercial interests, as well as the economical interests, financial interests of the state further amended the laws, at least in India, I'm quite aware, and to make it more difficult to challenge the award. There were a number of amendments, and I have that in my presentation, but I will not address it because this is much more of a general talk. So there was an attempt to sort of narrow the challengeability, for the want of a better word, of the award. This is something which I'm sure has been faced across all jurisdictions of South Asia. Some of the challenges were also as part of the presentation, which said different states in South Asia, in the subcontinent, have reacted to it differently. But more or less, the broader conceptions that arbitration awards have to be implemented, and that arbitration has to be insulated from broader impact of national laws, has been at the core of the new global consensus. Beyond arbitration, I think mediation is the new watchword. There are, we've all seen that the courts have now been opting for mediation. In Supreme Court, as Justice Lode spoke about, the court frequently, in questions of marital disputes and family law issues, even on commercial matters, courts at times do prefer conceptions of mediation. The court may sort of approach it in various different ways, but in marital disputes, it's the standard practice is to come to Supreme Court and ask for mediation. And so as a result, the Supreme Court has a special section, as a special organization which looks into mediation. Even the Delhi High Court, all high courts have that, and it is through where most of these specialized unit which even looks through and goes through mediation. Just like Delhi, we are all aware, Delhi High Court also has a specialized arbitration sort of, which has its own panel, arbitration institution, which has its own panel of arbitrators and so on and so forth. It also has a very well-known, especially in Delhi High Court, very well-known mediation wing. But Supreme Court's mediation center is extremely well-known, and a lot of disputes are solved there. Now, in India, mediation, let me put it this way, has been used by the Supreme Court very frequently. I think one of the greatest attempts by the Supreme Court was actually the Ram Janmabhoomi issue, where the Supreme Court appointed 3 mediators. One of them was an ex-Supreme Court judge and 2 other persons to mediate the Ram Janmabhoomi dispute. There was extensive parleys between various different communities and consultations, and I think eventually the mediation did fail. I'm not saying the mediation succeeded, but the fact was that it, by the end of the mediation process, a sort of consensus was built up amongst every party that what could be the contours of what could be a contour of a broader settlement. Of course, then the matter was judged. All parties said that irrespective of mediation, we want a final judgment of the court, and that's what it finally came. But if you saw, I'm not saying all parts of the mediation was confirmed, but the broad outlines, contours of what the settlement could possibly look like seems to be very close to what the mediators did at some point of time, speak to both parties and come to some sort of conclusion. Now the whole question is, what happens? What are the issues which we are facing? What are the issues which we are facing as mediators? One of the major issues, I think, is the mental block between commercial interests, between different companies, between us, between parties when they want to go for mediation. I, as a lawyer, have never seen clients willing to go for mediation. It's not that they don't prefer mediation. We know very frequently that business disputes are actually settled in back room most of the time by mediators, by middlemen, by sorting themselves out, by talking to each other. But business people are leery to take an institutionalized mediation path. I do not know why, but that's how it is, and people are in many ways skeptical. Business interests are skeptical. One of the reasons I think is because also we need trained mediators. As lawyers, I know friends of mine who have got onto this new wave of mediation, and they've been working at it. They've been training abroad. They've been training in India. They've been training on very frequently mediator workshops, which are very frequently the norm. And some of them have made a very, and I must confess, I must put it on record, very lucrative professions out of the mediation process. They've been very, very successful in that. But overall, they also seem to say that there is a reluctance of people, of the principles of the dispute, to actually to sort of accept the solution which is suggested by the mediator. So after a point of time, in family mediations, things solve themselves. We've seen it frequently, even as part of the Supreme Court. We know in family disputes, it's easier to mediate, and people do come to solutions. But in commercial interests, it seems like it's very, I'm not saying there are not, it doesn't happen, but it very infrequently does a composite solution accepted by both sides are arrived at in these mediations. So that's something which we have to look, to get more trust in mediators is something which we have to sort of concentrate and look forward to. Touched along with that, I think connected to that is the conception of something like implementation. Because again, we tend to, even if there's an agreement which arises between the both parties, then implementation tends to get caught up in legal trouble, in legal disputes again. So it goes back into a circle. Unlike arbitration, when there is an award, it can be implemented, and the law gives it that protection as an award which can be implemented as it is. In mediation, you arrive at an agreement, and then again you go into a loop. So that is something which we also need to sort of look into. Arbitration, for if we take it as part of the dispute resolution mechanism, has succeeded. There is no question of it. Good, bad, there have been some disputes which have broken from the international norms, some disputes, but overall, some judgments which have sort of tried to give national courts a bigger role in decision of issues, in deciding up on the decision of arbitrators. But largely, more or less, the consensus now is that people have to learn to accept the awards. People have to awards which have been decided by arbitrators, whether chosen, not chosen, chosen by the court, chosen by the parties, have to be implemented. So that's how it is. It's also because that may be the global norm. That is also the global demand of having such sort of a mechanism. I completely agree with Honorable Chief Justice Perez that we need to have subcontinental centers of arbitration. It's extremely important. I know for a fact, because I've been partially involved with it, there is an attempt to have this sort of a center of arbitration based in Delhi. And this is something which we should all think about. And I'm not talking about places, about specific places, but as the economy of the subcontinent becomes increasingly integrated, and I think barriers of trade become increasingly are lowered down, it makes perfect sense. It makes perfect sense to have institutional arbitration where we don't have to actually go to Singapore. Whether it would be wonderful for me to be able to go to Colombo and do something, or to Dhaka and to have my arbitration if need be. Because in addition to that, we share a lot in common. We share the legal systems in common in many ways. I know in Sri Lanka there's a slight difference, but broadly the legal systems in common, and the same sort of legal system stretched at one point of time from the borders of Myanmar to the borders of to the Khyber Pass. So and from the south, from Sri Lanka to Kashmir. So we've had this very vast, continuous system of governance, was largely governed by a similar system of laws, and we can have commercial arbitration, at least, which relies on similar jurisprudence, commercial jurisprudence, to decide this issue. It would be incredibly welcome step. Now, coming towards the end of my small presentation, what is the impact of the pandemic, and on what do I think is where are we going with virtual courts? These are the two issues. On the issues of the pandemic, I think the pandemic has impacted us tremendously. The Indian Supreme Court had to intervene, and sort of that one-year law which Justice Perez spoke about, that you have to finish arbitration within 1 year. The Supreme Court had to extend it by a grace period, because the Supreme Court was of the view that it wasn't feasible to complete arbitrations at that point of time. Even now, the courts are not functioning. There are virtual courts, there are partial virtual courts, there are mixed courts, the hybrid courts. But the pandemic is a fact of life. It's very, very difficult, even at the present moment, to get work done. So arbitrations have suffered. But it was easier to handle arbitrations because, for the very simple reason, arbitrations could be done virtually easily. Even if witnesses had to be examined. They could be examined on camera. It was nothing unusual. It was done before. Unlike courts, where there is still a major sort of an issue as to whether it can be done through courts, and whether witnesses have to be personally examined, or whether they can be done visually, can be done virtually. Now, interestingly, and this is something which will have a huge impact today, I think the parliamentary panel has submitted a report to the Vice President, I think yesterday or this morning, which spoke about how we needed virtual courts and what is the sort of infrastructure which we need, and why it said virtual courts and tribunals make justice easily deliverable and makes it cheaper and accessible across the board. I think in many ways, ADR, whether it be in dispute resolution system through mediation, or whether it be dispute resolution through arbitration, virtual court systems like this, as we are in this sort of seminar, would have to become a mainstay. It's easier. It's you can do it from anywhere. I have lawyers who participate in Indian Supreme Court hearings from London very frequently. I know they participate also from Australia. I've seen that. I know lawyers who participate from different parts of the world, different parts of India, very frequently appearing before the Supreme Court, but they wouldn't have done that before. So I think if it's integrated, you don't have to travel across the world. Now we've also realized you can read documents. Documents can be sent across to all the judges, to all the counsels as files, PDF files. I've got myself a wonderful iPad and a laptop with a stylus on which you can actually mark and edit documents. You can underline documents in different colors. You can write notes. In fact, my note which I prepared to speak here was written on an iPad. So we've got used to it. I think it would be here to stay, and be easy to implement it on alternate dispute resolution systems. In the end, where do I see this? As I see this, the pandemic has had horrible effects. It's been very difficult for the court system to run. But in many ways, the technological changes which it has brought in will be very long-lasting, if not everlasting. And I think the maximum impact on this practice of virtual dispute resolution system would be on the alternate dispute resolution system. And so I think it would be now very easy to conduct alternate dispute resolutions across frontiers without asking for a visa, without traveling. So I know traveling is part of the wonderful experience of being part of the alternate dispute resolution. But I think in an integrated, increasingly integrated subcontinental economy, this would be the best way. Thank you.
Thank you, sir. Thank you, sir. And should I say all-encompassing and comprehensive? That is what Mr. Banerjee has always been. He has touched all the contours of the topic. Mr. Banerjee, his deliberation, should I say this way, has been a proficient blend of wrapping up on the topic and dovetailing it with his own ideas. Mr. Banerjee has also brushed up on that part or that side of the topic, which is very less spoken of, that is the philosophical side, dharma. Well, should I say this way, that by chaining down and by command, one may not generate allegiance, but certainly by evoking conscience. That is what is needed. Mr. Banerjee has addressed the chink in someone's armor by discussing issues relating to enforceability of awards. Thereafter, Mr. Banerjee has also put forward some practical examples relating to mediation by mentioning about the mediation which was involved with the Ram Janmabhoomi case. And he has also addressed the elephant in the room by mentioning about his views as to how one should go about in this pandemic situation relating to area and all these things. Uh, he has mentioned about illuminated and dark sides of the pandemic so far area is concerned. Well, with this, may I thank all the honorable speakers we have in this panel. But before concluding, I would just embark upon that concluding part of this session where we would also like to have the opinion from the other two honorable speakers on the same issue, which Mr. Banerjee has just mentioned about their views, how India should go about in this pandemic situation. So may I just put this question on the floor? So, Honorable Launches and also Sir, you feel free to address the issue.
Yes, Justice Lodha, you can. Would you want me to say something first, or would Justice Lord wants to say something?
Yeah, well,
In my opinion, in this pandemic situation, it is very difficult to conduct ADR, to adopt ADR method through virtual course. Virtually, it is not possible in a state like Tripura or other northeastern states. I don't know. I don't have any idea about other states. But I think in metro cities, in some of the metro cities, it may be possible to resolve the dispute through virtual hearing or discussion. Because online system cannot be, and people should be acquainted with the process of those things. They have their own laptops, they have their notebooks. The area of the need in network, so in many areas of the state do not have that facility. So in some things it's very possible, in some areas of states it may not be possible. But if it is made possible, then definitely it will work out. We shall resolve the disputes through ADR in this pandemic situation also.
thank you, Mr. Justice Lord. May I now request Honorable Justice Paris?
Well, I agree with
share his
everything
views on
what
this.
Solicitor General Banerjee and Justice Lord has said. No question. But let's be absolutely kind of candid about this. The working online in a virtual environment is very convenient. No doubt. Very, very convenient. I'm not too sure whether it's really a substitute, perhaps, for real-time hearings. Although real-time hearings and perhaps whether it is a substitute for perhaps human mind, whether it's a substitute for humanity itself. In other words, where is the judge I want to see? Where is my counsel who is protecting me? Where is my client? You see, if you reduce ourselves to just a binary notation in cyberspace, I think we're abdicating humanity. I think that we've got to remember. See, we can't be binary notations. Why it is easy to deal with people online, is because they're so far away from us. We don't have to be fearful at all. We'll have a million friends, right? Simply because they are so distant from me. I don't have to worry about it. So, you see, we've got to be conscious of that. In as much as this is a very convenient arrangement. What I mean is, I can be in the comfort of my home and be trying a very complicated trial. Now, I'm not too sure whether, after all, we've got to we've got to get into a particular mindset, isn't it, to deal with certain issues. If I can't be casual about if you make life casual. I'm not too sure whether we can be casual with, for example, when we are deciding on the liberties of subjects. I don't mind, but I mean, it's okay. If it's a financial contract, well, I might make a mistake or two, I can review it. But if I was to sentence a person to 10 years rigorous imprisonment, sitting casually on my couch at home, right? I'm not too sure whether that's virtually like playing God. Remotely, it's like, now some of us judges, now I can tell you, we as judges and you as being a Attorney General's chambers, we are, I have been in the AG, I have been the Attorney General, so I know what it is. It's very easy. We see a criminal, we know a criminal when we see a criminal. Those are there. We look at a man and say, oh, this chap, I don't quite like the fellow. Let's make it 10 years, 5 years in the next fellow, without a slightest idea of the principles of sentencing. Nothing. It's so arbitrary. My worry is that arbitrariness might be taken to a different level in this kind of casual environment that we are working in. No doubt. You see? Now, I find some of my friends who are working from home. Now, they're supposed to be working from home, but they're pretty relaxed. But I mean, I'm fairly sure the agenda for the day is not as strict as if I would have him in my chambers. Yeah. So my candid view is that I think we mustn't get carried away by the euphoria of working in a virtual environment. We make use of cyberspace. Let's work in cyberspace. You see, shall I put this question this way? Did we need a pandemic to realize that we've got to really work hard to dispose of our cases? Did we really need a pandemic to jolt us out of our slumber, so to speak? Did it need a pandemic to realize that we are all born equal? Did it need a pandemic for us to realize that we were all equals before the law? Did it need a pandemic that the vulnerable groups are just as human that we are, that they're entitled to be respected just being human? So what is this new thing that we have suddenly discovered? What is this new thing that we have discovered? Today, people are not worried about their religious diversity. They're not worried about their cultural differences. They're not worried about their gender differences. There's only one thing they worry about, and that is survival. How do I live tomorrow and protect myself against the pandemic? If I have to get help from the smallest of fellows in a scheduled tribe or in a scheduled caste, I will do that. I will probably even take his blood and transfuse myself with it if it means life for me. Now, surely, look at the morality of this. So thank God the pandemic actually probably got us to realize that there's much more to life than that. Humanity means much more than this great diversity, this constitutional sophistication that we are enjoying. Look at our constitution. You provide for scheduled tribes, for scheduled castes, what not, 103 amendments. How much have we proceeded? Same for Sri Lanka. I say the same thing with Sri Lanka. How much of progress have you achieved? No doubt, material progress, yes. But in terms of maturity, constitutional maturity, how much of constitutional economics do we actually practice today? We don't have any idea of what constitutional economics is all about. How much respect do we give for constitutional values? Look, when I saw those pictures, people walking on the highway in Greater Noida towards Uttar Pradesh, the very people, the workers who actually were working on those huge condos, high-rise 45-floor condos, have no place to go. They're walking by it without knowing where they were going. Hungry, what? But very few, we were not too moved with it. I'm saying this because I had to do a lecture on COVID-19 and, of liberties of subjects and so on and so forth. So what I'm saying is, if we can only learn the lesson that even post-pandemic, let's say, okay, the pandemic ends tomorrow. We get a great vaccine and we are back as healthy as we can be, and we can do whatever we can and enjoy our liberties as freely as we want to. Are we going to continue doing what we are now doing with the same enthusiasm? Or are we going to go back to our same good old ways? Will we judges be starting to work more? Will we come to work at 9 o'clock and work till 5 o'clock in the evening? Will our lawyers start charging less fees and be a little more human in what they are doing? Will our prosecutorial discretion be a little more human? Will we facilitate the community to get on with life rather than be a bloodhound? Now, these are questions that really worry me. So, I find the pandemic pretty useful to the extent that they have jolted people out of a false sense of patriotism. Today, you are worried about your own communities rather than blasting your neighbors on your borders because of the pandemic. Right? Just look at the transformation. But what I want to see is that this mindset, this transformation must continue even post-pandemic when things get back to normal. Will very soon, you see, very soon we will actually be bored with the kind of with the leisure time we already have. Because we are not born to be this. We are all social animals. Can we be distant from our neighbor? We are in a culture where my next door neighbor knows more about what's going on in my house than I would know. That is the kind of cultures we live in, whether we like it or not. So there you are. So it's right. What I mean is I fully appreciate what Mr. Banerjee and Justice Lord said. You're right. To that extent, it's fine. It's a perfectly, just look at it this way. Without bringing a prisoner from the remand prison, we say, okay, we are trying you. While you are in jail, I'm going to try you here. One of these days, like what England did about 1 year ago, if you read the case of the Queen versus Chahal, an Indian national who challenged the extradition when he was about to be deported out of England, Chahal's case, the famous the Belmarsh case. If you read the Belmarsh case, they assigned, will you believe it, that England assigned counsel for the accused who had never seen his counsel, and counsel had never seen the accused. Chahal never saw his counsel, and counsel never saw Chahal. He was called a special counsel. And it went up to the European Court of Human Rights. They struck it down. Came back to the House of Lords. They struck it down. Right? Now, we might start doing strange things under the guise of the pandemic. Just assume if you start assigning counsel, if the AG tomorrow starts assigning counsel to people whether they like it or not, here is counsel. Surely, is that a suitable arrangement? So I think we need to be careful, in other words, not to take it to such kind of absurd extremes. Let's build in some humanity into what we are doing. You see, you can't build in that humanity to our devices, not to my iPad, not to my iPhone, not to my computer or whatever device that I'm using. If the day we get to, I think the day we get to building our putting in our emotional input to our devices, I think that is the day we would probably abdicate our humanity. In other words, I think the parameters must be clearly understood. This is certainly a little stopgap because I really fear, I think all of us are experienced enough between ourselves, experienced enough to realize what goes, the real time behind the scenes action in our courthouses. What happens, and mind you, we are in a We are in a hotspot of an environment, isn't it? We are in a melting pot of, today we know the separation of powers. All those things are very nice things on paper. So, but here we are now bringing it to another level where we won't even know what a judge would do because we don't see him. You see this argument of judicial independence. If you read, for example, the advocates on record cases, one of the arguments that was placed there, one of the arguments for the judges was that judges actually, they were very proud of the fact when judges talk of their independence, they say, well, look, why are you critiquing us? Because we do everything in the open. We deliver our judgments in open court. Our judgments are available to be read. Our judgments are published in the newspapers. In other words, there is nothing they said, don't worry about accountability because we judges do everything in the open. Now, if you start doing in a virtual court, where is that transparency? Where will that be? What would happen to all that? So really, unless, of course, we judges are willing to concede some of the need for accountability. I think this is perhaps this is a time testing time for the judiciary, I say. Because if you start adopting the methods of working in cyberspace, I think there is all the greater need for judicial accountability. Because to do anything otherwise would be perhaps lending the system to great peril, because there'll be a lot of things that will happen in cyberspace that none of us probably we'll be dealing with phantom judges, phantom accused, phantom attorneys general, phantom, everything will be phantom virtually. And we'll be probably dealing with phantom dragons, as some judge said it in England, right? So I think we mustn't phantomize this by generously resorting to cyberspace, but probably get down to the realities of it and probably have a very strong control of our activity in cyberspace. Thank you.
Thank you, Honorable Chief Justice.
There's one small clarification.
Yes, sir. Yes, sir.
I think to be fair, at least from my side, what the committee has just submitted the report was not that it would say that every aspect needs to be put into virtual domain, but it also clarified that in some aspects, largely commercial, as Justice Perez largely also touched about it. Commercial issues and commercial matters on APTEL, on tribunals, which are largely dictated by commercial interests and high-end commercial interests, they could be decided by virtually. I think in many ways, maybe to that extent, they're right. Otherwise, they have consistently also maintained that definitely they don't want to go and there is no substitute for courts. Just to clarify the factual position. Right? I don't think I should, as representing the government, I don't think I should give a wrong impression.
No. I've been representing the government virtually my entire life. So, but I know exactly what you're saying. But just that, we've got to, how much of automation are we going to apply? Yeah.
Well, very extensively and very candidly, all our honorable speakers have dealt with this issue. This issue is such that more you speak on this, more your hunger doesn't quench. You more have appetite for listening to it. Well, due to paucity of time, maybe we may not be able to continue with this. But with this, Mark, let me conclude this session, and I would like to thank on behalf of CIATR all our honorable speakers for giving up so much of their precious time and upskilling us so aptly. I would also make a small request before we conclude and part that in future also we would want to get nourished by such beautiful thoughts and lively thoughts and educated thoughts. So putting this request before all the honorable speakers, we would like to conclude this session and call it an end. And a happy ending for this. And let us pray to Almighty that this epidemic may see a end to it. There should be an end to it. And all may the world may be at peace. So thank you,
Thank you.
all the speakers. Thank you all.
Thank you,
So,
thank you, Kohinur, and thank you, Justice Lord, and thank you, man.
Such
Such
an
a
honor.
pleasure being here.
And such an
Lovely
honor, sir.
listening to
Such
you.
an honor.
Yeah,
It's
and
an
let's. I hope we keep in touch, and all the best to you.
Mm.
And I hope, as Kohinur said, that the world
See
will
you,
return to
as they say, see you on the other side, sir. See you on the other side of this.
exactly. See you on the other side. Of course, of course. Okay, all the best. Right,
Thank
I'm leaving. Okay, goodbye. Bye bye.
Thank you.
Goodbye.
Thank you all.